Call the meeting to order. Call the roll, please.
Lloyd Foster.
Lloyd is at the doctor's office.
Jim Neiman.
Here.
Aaron Leckie.
Here.
David Campbell.
Here.
Sean Perry. Here. Jeff Simpson.
Here.
Doug McCain.
Here.
Rob Arnold.
Vacation.
Joe Taylor.
Here.
Thank you.
Okay. This is a special board meeting of the county board to consider the ambulance contract and settlement. The settlement is not the one we've already agreed to. It is a settlement that has to do with a settlement agreement between Abbott and Altamont Ambulance Service. But since we're a party to that, as part of that other contract, we have to approve of it or disapprove it. Before we get started, I did not include a session on here for comments, and if anyone would like to make a comment to the board before we go into executive session, please raise your hands now. Okay.
Good.
Councilor
My name's Adam Houston. I had talked to several of the county board members, actually, and one of the ambulance oversight members as well. And the last meeting that you guys had, that you voted on the settlement agreement, you guys have told us that the ambulance contract would be made available for public viewing before it was voted on. I would like to know if that has been done, why, and when that was made available for the public.
It has not been made available to the public yet because they were still working on it as late as this afternoon.
So your closed session ambulance contract is dealing with the contract between those two ambulance providers?
There are two things. One is the purchase of the previous contract from Altamont Ambulance by Abbott. That has to be approved by us. The second one, and that's their settlement agreement. The second one is the contract between the county and Abbott Ambulance Service.
So you're going to discuss the contract between the county and Abbott in executive session?
Correct.
What
The attorney,
provision?
our attorney is going to be explaining it to us. I take questions.
What provision allows you to discuss that contract
It's
in
still
executive
pending litigation.
Not a contract is not pending litigation. The litigation, as you explained, is between those two ambulance providers that you have to approve some sort of agreement between those two. And then you said there's two separate contracts, the next one being between Abbott and the county.
The entire settlement, including the one that we signed back in March, is all predicated upon this all occurring. If this doesn't occur, that is all null and void. Am I correct on that?
That is true, and the reason this has taken so long is that all of these parties have had to work together, and they've done an amazing job. But yes, in fact, I want to review with the board members the latest revisions of the contract in closed session. It's been distributed, but there are questions that need to be answered. But the entire settlement, even the one that we approved 2 months ago, is all contingent upon everybody agreeing in writing. So that's why it is part of the litigation. Now, again, I don't think there's anybody in this room that doesn't mind sharing the terms of the contract, and certainly we can do that, but I think the board members need to know what that is before we share it.
But my question is, what exemption authorizes you to discuss the contract? I understand the litigation, and it's supposed to be limited to, yes, we approve the agreement between those two parties. Discussing the contract or any terms of the contract, and number one, I don't think you're the state attorney, and I don't know if you've been appointed by a court to represent the county.
I have, thank you. And Mr. Killer's here too, I'm sure he's happy to.
But I fail to understand where in the Open Meetings Act it authorizes you to go into closed session to discuss a contract between the county and a private entity. I don't think you'll find that. The litigation should be limited in scope to, yes, we approve the sale of one ambulance to the other ambulance, period, and then come out here and discuss the contract.
I respectfully disagree.
Well, make sure you record it, because I'm gonna try to get a copy of that recording.
You always record?
Yeah, they're all recorded.
What is your name, please? What is your name, please?
John Kraft.
Thank you.
Anything
Hey,
else?
Chairman, yeah,
Yes.
Kirk Allen, we corresponded earlier this
Yes,
morning.
correct.
Couple of quick questions. I do see now that the notice for the meeting is posted on the website. It hasn't been posted on there until you took care of that. I appreciate you taking care of it. I haven't seen any posting anywhere else for the meeting. We've acknowledged it hasn't been published in accordance with the county code, so my question is this a legal meeting? The importance of that question isn't to say, hey, guys, you're having a meeting you're not supposed to have. The importance of it is, you're fixing to make decisions that relate on a contract you've been fighting with for years. If you do it in an illegal meeting, guess what? It's real simple for any party to come in and invalidate the work that you just did. So I would hope that this meeting is a bona fide legal meeting, because posting requirements don't appear to have been met. That's all I have, thank you.
It was posted downstairs, wasn't it?
We posted with the Open Meetings Act. What he's saying, there's a provision in the county code that, for our particular form of county government, Kurt brought to my attention, that requires, well, concurrence from board members to have a special meeting, or from the majority of a quorum to have a special meeting. And it also requires publication. And we did give to the press, but it did not get published.
If it-
As far as the OMA compliance, how are we compliant with the OMA? Because it wasn't on the website.
Is there a time frame on the website? Because, like I said, I got, as soon as I found out it wasn't on the website, I had the IT guy put it up.
Meeting notices have to be posted 48 hours in advance.
On the website as well?
Yes.
Yes, sir. I think your legal counsel can confirm that.
I'll be back in just a second.
I guess not. Partly, our fault that it didn't get published. It got there. Then it happened. Right.
But the news had it.
Yeah. And it's not our fault that it didn't get published. Because they had, it just brought it on Friday.
Probably has that. What page are you even on?
I showed him sold our farm one time.
What page are they even on?
You read it in somebody. No, we finally set a pinned a notice to a tree. Well, they were sending the tax bills. My brother's previous address in Missouri, nobody was living there, so.
Can we get paid?
I helped the guys get paid, so I wanted for taxes. Finally caught it. Things stuck to the tree. I finally seen it, so what's that? Farm's nice. No, we went back and paid it. It was done. Posting, yeah, it just happened to be on. If it would've been a month later, it would've actually.
Holly Body has a website, you get full contract.
It was 3 years.
Oh, it was.
You see,
gentlemen?
Yeah, come in.
Somewhere other than Effingham.
Sure, that's 48 hours.
I can still play house.
You're sitting next to us, rubbed off.
My ears probably still, I had it. I caught something from Abby. She had it, I think, in the hospital.
Yeah, probably.
And I caught it, and her hearing is just now coming back. It's been like almost 2.5 months. And my hearing in my left ear is like I got waters in my ears.
Only thing I did my shot was real good this year. And I hate it because my shot was real good this year. I hate it. Shots. About 10 shots. They want, you know, this, I'm getting that age, I forgot just like a fish and otter.
For every first 5 years. They do 1, 2,
And he was missing like 2 pins, and Charlie tracked them heels. He found him what he needed to fill in to get them all out.
Really pumpy.
Anybody's really wants them.
What's everything good? That's great. This is in my life. Huh? Not too bad. You want to spray it, but I don't think you'll always. See, I sprayed last fall. It's really weird to think my bean ground. It was last year's bean ground. I got one this year. Sprayed it.
Yeah, they made them.
Some of the corn and some of the fields are doing some on me. Where I like that spraying. I didn't work in ground like anything. I was there if I don't work ground, I work away now. What?
Those can't be in there.
I might start.
We need alcohol.
No, I'm not from the hell room, but I got some home,
Yeah.
Yeah.
I got it. Are you on the SCS program?
No, I've never wanted to make it.
Why don't we just keep your guy, why don't we just keep your guy with dogs? That new guy responded.
They have cans.
Oh, yeah, but could we stay there full time? Yeah, but he's one, full, is he a turn?
I think he's the full-time show.
Exactly.
Oh, he is an AD, I thought maybe he wasn't an AD. Oh, you see, like, he came out of the bench. I like him, yeah. And then when we hire him.
Brian?
Yes, Jim. I believe what's happened here is the county obviously published it 48 hours before today's meeting. Obviously, it's gotten a lot of media playtime, so I know that notice has gone out and,
Where was it published?
well, it's been out, so give me a second here, Kirk. The county has done its best to get notice out as best we could, and it's obvious by the attendance here today. While I somewhat disagree with the interpretation of Mr. Kraft and Mr. Allen, this issue is too important for us to take any chances on. And while we have, I think the issue ultimately becomes is the publication on the county website 48 hours before the meeting. While we disagree with what Kirk and Mr. Allen and Mr. Kraft are asserting, I don't want this to become an issue that comes back to haunt us, because we spent 4 years on this litigation, and really 8 or 9 if you go back to the original suit. So what's another week? So what my recommendation is to have Carrie formally send notice of a special meeting for June 2nd, and I forgot what time you wanted to do that, Jim. And we'll just do it there. We'll have Jason, hopefully he hasn't left yet, we'll have Jason posted here this afternoon, and we will put this on the door downstairs, and we'll be in complete compliance, and no one can say that we didn't do it. And I just don't want this to be a statutory interpretation.
With all due respect, what is it you disagree with what I said?
About the 48 hours of the website. That's what I'm
just saying
disagreeing with.
48-hour notice for the posting.
But why are we, we're citing to what you want us to do, so I don't know why you're trying to argue with me when I'm giving you what you want.
With all due respect, I'm not trying to argue.
And you're the, I mean, you guys bring some points, and I think as lawyers, Chris and I can probably argue either way on this issue. So I'm not wanting to cause a mass disagreement here. What we're gonna do is err on the side of what you guys are asserting, and that's fine. And this has gotta be obviously out in the open. So, and there's really there's nothing to hide in this contract. So we will reconvene this to June 2nd if we can get a quorum. Will that work for the lady and gentleman of the
Do
board?
I have a concurrence from at least 2 of you to have a special meeting on June 2nd?
It's a Friday.
Yeah, that's fine.
Dave, Joe?
On Friday, I'm gonna.
Well, I'll leave it to you guys. You guys tell me
Early?
your schedule.
Out, what time are we talking?
Early?
What works for everybody? We don't
Well, I gotta work in yoga that evening, so.
We can go earlier.
Early afternoon or even morning.
Morning sounds better. I mean, I don't know if you're on the farming or anything next week, you think?
Joe?
You can pick a time, I'll be here.
I like to in the morning sometime before noon.
Okay.
10 o'clock?
And just for the record, I agree with Mr. Kilber. I think it can be argued with regard to whether it does or does not have to be posted on the website, but
I didn't say
Far-
website,
far
I said
too many
posted
people.
48 hours.
far too many people have worked far too hard to get where we are, and this is a good thing, to let what has been achieved by the people in this room, these board members who work so hard, and a lot of the people in the audience, to let it, that there would be a cloud regarding publishing the notice. So I agree with Mr. Kibler, and Mr. Allen, you'd send me an email, happy to call you back, and happy to discuss it with anybody. So I agree with Mr. Kibler.
So we're just gonna err on the side of caution and what certain people in the room are suggesting as the law. We certainly don't want to violate it. I don't think we've intentionally done anything illegal here, so let's just continue it. I mean, it's been going on for years. What's essentially another, what, 9 days, 10 days? I know, well, that's easy for me to say, Jim, I'm not the one living with it, so.
All right, since we don't have a meeting, we don't need to adjourn.
Well, I have a question for you. Now that the contract has been decided, you said that it has been decided on, and it should be made available to the public as what you told us in the last meeting, is that correct?
But I think what they're saying is the contract technically hasn't been resolved because there's a third piece, which is the potential litigation between the other.
The actual ambulance contract is what I'm asking.
Well, actually, Mr. Houston, in fact, you're welcome to call me too after the meeting, or after what we're here, but as early as this morning, Walt Landon, who is Abbott's attorney, called me with a requested revision, which I immediately shared. So, again, it wasn't a major revision by any stretch of the imagination, but that's something we're going to discuss today that we've not had a chance to discuss. But if you have questions about that, you're welcome to call me.
Is there anything wrong with fielding any other questions since we're here, even though we can't act on anything? I mean, if anybody else has got any questions, is there anything wrong with that?
I guess, I mean, it's up to you. I mean, it's technically not a just the public wanting to comment, you guys are sitting here, if they wanna jump up and comment, I guess they can. I don't see a problem with that.
My name's Aaron Fritcher. I have a few questions about the incoming ambulance service. I had went to their meet and greet for the community and found out that they have indicators for crew pay for performance plan. So if you meet all these indicators for a certain amount of time, usually 6 weeks, you get to get either 50 cents or $1 pay raise for the next 6 weeks. Now, all of these, start of shift time, turnaround time, time on task, all these have nothing to do with patient care or any facility satisfaction. All it has to do is either basic paramedic, by all means, or their time on a call or time that they're at the hospital. Now, when you are encouraging your employees via money, which is how the world goes around, how are we supposed to think as citizens that our lives are going to be safe when all they're thinking about is time on task? Stated very clearly in their pamphlet.
Okay. Any other statements?
Oh, that wasn't a statement, that was a question.
You don't get a question, you can make statements.
Oh, thanks, Jim. Have a nice day. And, well, I'll make more statements then, since this isn't truly a meeting. So have we thought about things like coverage for the 4th of July? Or how many ambulances? Does anybody in the room know how many ambulances are going to be in the county?
3 in the contract, I believe.
Oh, you've seen the contract. Oh, that's nice. You don't even live in this county. So he's privy to a contract, but the citizens, we don't need the contract, right? It only affects us. I hope and I pray that your actions and what you're doing with this contract don't personally affect your wife or your kids or your loved ones, because it could.
I think to answer your question, and maybe the 3 comment was, and again, this is a nuance that if we want to get into the weeds, I'm happy to just make a comment, but I congratulate Altamont Ambulance and Abbott and all the 911 folks and the telecommunicators and the board members. They had to get together and coordinate their efforts on the transition plan. And because that the actual 100% transfer will not take place for 60 to 90 days, the existing contract that we all hate will remain in effect until the final assignment is made. So in that old contract that everyone hates, and rightfully so, there were 3 ambulances that would be in the county.
Chris, do you agree that Abbott has put the cart before the horse as far as saying that they posted on Effingham, on their Facebook page and social media, that they've been awarded the Effingham County contract, that they have made Effingham County their home, that you're hiring people? How are they doing that with, I mean, nothing has been approved at this point?
That's a good question, Adam, and I'll answer it this way. Basically, again, there were months and years that have gone into it, but months of the settlement discussions that involved Abbott and Altamont. And again, my hat's off to the Altamont folks for being able to work with everybody in a difficult situation. But we had to proceed down parallel tracks because, Adam, as you know, it just doesn't happen overnight. There's no way that we could sign a contract where an ambulance provider is going to take over on a Tuesday after the other one gets out on a Monday. So I don't know if that answered your question or not.
Well, I mean, I understand that, but I understand, but you've also just said that it takes 60 to 90 days to get that transition period.
Mm-hmm.
Well, you would think after, it'd be 60 to 90 days after you guys have taken a vote to get the process started to say, okay, hey, we've been awarded the contract at this point. You know, I'm very familiar with ambulance services and the contracts and so forth. That they would, at that point, whenever it's voted on by the county and you get a vote saying, yes, we're going with Abbott, then they make the post, and then they start hiring people and so forth. Like I said, it sounds to me
I
like.
would say, Adam, actually, I would say, I don't think they are getting the cart before the horse. What I think everyone is doing is working together under faith that they are going to approve the contract and sign it, because that's the way it's got to be done. And frankly, I suspect the board, you know, that's one thing that we like about Abbott, is they are willing to do those things and take those steps before they even have a contract. So, again, when we got together with Judge Lowley, it's been a couple months ago now, and explained the terms of the proposed settlement, and no one was happier than he was. He also understood and congratulated everyone to suggest that, thank you for being able to work with each other in good faith after this many years of litigation. And that's what has been happening, and again, that is to the credit of the Abbott folks and the Altamont folks.
Can you explain the ambulance vetting process that the ambulance oversight committee performed, and what other services were contacted, interviewed, and so forth?
I can tell you this, Adam, is that when I got involved in this litigation, the injunction had already been filed, and I was there to handle litigation. I don't profess to be an ambulance expert, and I was not involved in the vetting process. All I can say is that, and you know a lot of the ambulance oversight committee members and the folks on this board, they did yeoman's job in going through the vetting process. I think it would be inappropriate for me to explain that vetting process, but I can assure you that it has been done.
Well, if we've got members of the ambulance oversight committee here, maybe they can explain it.
Again, I don't know how long. I think we're erring on the side of making sure everyone understands what's going on, because it has been such a difficult process. And I think...
I don't think the process has been open, is I guess what my question and what I'm saying.
Well, Mr. Twister?
Come to a meeting, maybe you'll learn something.
I'm at a meeting and I'm asking.
But again, well, maybe it's not technically a meeting, but again, I really, it's always darkest before the dawn, and I think no one wants, this is a lot of hard work by the people around this table and out there, and they are to be congratulated. And Adam, if you have any questions about the contract or anything, I'm happy to talk to you, just like I talked to Mr. Allen.
No, I understand that.
Okay.
Yes, Kurt.
Yeah, Chair and Chris, if you could, you may or may not have in the review of the previous contract, you had mentioned earlier when we spoke that there was some evergreen terms in the other one that was part of the big hurdle. Have you folks looked at the Auto Renew Act that forbids evergreen clauses for government entities?
We have looked at everything, and that would have had to be litigated. And one thing that, again, I think that is...
That specific
yeah,
act on
yes,
auto renewal?
Yes, thank you. And then I think the major accomplishment, and again, it's faith shown by all three of these parties. The major accomplishment is that everyone has agreed that there is going to be no situation where you have to prove a major breach. I mean, basically, each side is going to have the ability to get out of the contract 90 days without cause. It can be sooner for cause, but that in and of itself, I guess, displays to me, it illustrates the willingness of all parties to make sure they continue to work together, not hide behind a difficult, if not onerous and illegible contract, but listen, it's going to be like a marriage. We are going to work together, and we're going to. So that was the biggest hurdle, and again, I commend all parties for overcoming that.
My last point I wanted to make in regards to, I understand technically you're not in a meeting right now, and that's why you can't respond. From a transparency standpoint, OMA outlines they have a right to speak, and like you said, they can make a statement. The county code actually outlines that at every meeting, you're required to set a time for employees and citizens to ask questions. And that legislative intent was to get answers to those questions, just as a future reference.
There's actually a piece of legislation moving through the House right now that would allow questions and require answers. That's not the case right now. It's simply a statement.
Well, under the county code, when you look at the legislative intent of that particular county code statute, it's in the school code also in universities, and the legislation you reference we've been pushing that for over a year now, that the legislation for county code, the intent was to get answers to the questions, and it's a great transparency tool to have that inner dialogue with respect and decorum. I understand, there's times where it can get out of hand, but there's nothing better than getting answers to questions. Chris, I do appreciate you trying to answer some of the questions, because it's tough when the public doesn't know things.
Absolutely, and also go back to Adam's point, is with regard to getting the cart before the horse. I think it was also a major accomplishment for everyone to agree that we need to start now to talk to these, the Altamont employees, to see who would want to come on board with Abbott. So we, because I don't think anyone's ever had any problem with the employees. They've done a wonderful job. So again, those are the kind of things that had to occur in faith at the same time, before you actually had all the I's dotted and T's crossed. But thank you both.
I guess this is a comment and a question all together, but whatever, but to make you guys think a little bit. I kind of have the opinion, and I think a lot of people here do, that probably the decision's already made. But I think one thing that needs to be considered is the fact that, why do we even have to contract an ambulance service? Because from what I've been told, there's as many as 4 ambulance services that want to come here. Now, I've heard several times that, well, we only have enough business for 1 ambulance service. That's a bunch of bull. Show me the proof to that. I've never seen proof to it, and I bet none of you have either. We used to have 2 to 3 ambulance services operate here, and they all made it as long as they did their job. The thing that I think that you need to consider is, if you as a county board dictate that this particular, whoever it is, and I don't care who it is, this particular ambulance service is going to service the people of Effingham County, and they prove to be not the best service, they're not fulfilling their obligations and so on and so forth, that's going to put the county board and the county into liability. You said we have to use this ambulance service. So if there's a lawsuit that would ever come up against the ambulance service, the county board's going to be named in that lawsuit too, possibly, because you said this is who we have to use. So, you can get out of that liability by just letting ambulance services come, as long as you got, and the way I understand the way the law reads, is if there are ambulance services that are willing to come and provide service in the county, you don't have to have a contract for an ambulance service. So I just think, open it up, don't create a monopoly, and let it take care of itself. It will.
I think to a person in this room, I think everyone would say, monopolies are bad, we don't like monopolies, undoubtedly. The reason the statute was enacted in the first place, which allows the county board to contract with 1 ambulance provider, is because the statistics showed that when you had 2 or 3 or 4 ambulance providers in a town, that there wasn't enough business to satisfy all of them, and then your services went down. That's why the legislature, after much study and consternation, said you can do it. I would say just the opposite is true. If the legislature told you this is what's going on in the state of Illinois, and here's why we're going to allow an exception to this case because these things are happening, and you didn't do it, and something went wrong, maybe you had 3 ambulance services in there and for whatever reason didn't happen, I suspect this county would get sued, saying you didn't take advantage of the statute that we provided to you to ensure that the service is going to be good. But from a philosophical standpoint, with regard to monopolies, I agree with you, and I think everybody else would agree with you. But I appreciate your point there. That's well taken.
Well, and the thing of it is too, that if you have 1 ambulance service, then they can charge whatever they want. They're pretty well in whatever they want to do. If the county wants to regulate ambulance services, they need to come in with an ordinance and say, okay, any ambulance service that comes into Effingham County and wants to conduct business here has to meet these certain obligations. Here's what you gotta have, here's what you've gotta do, here's the certifications that you have to have, and set that up where it's a top-notch outfit. If they do not do that, then,
You take up with the 911 calls.
yeah, you just say, you can't operate in Effingham County because you do not meet our requirements. And you can have the best ambulance service in the nation if you set it up that way.
That's what they're doing. That's what the board is doing under the new contract.
But you're limited to one ambulance service that's been picked years ago.
And if they don't satisfy their obligations and do a great job, they can be let go immediately or in 90 days. We have every reason to believe that they will do a great job, but if they don't, there'll be another one.
Any other comments?
Will you still be releasing your press release, or is that?
Not today, not till this thing's signed.
Okay.
All right, take a motion to adjourn since we didn't put it in.
So moved.
Motion by Karen, second by Jeff. Any discussion? All in favor, say aye. Any opposed, same sign. Motion carries. See you on June 2nd.
By the way, this is for
10 a.m.
everyone.